Welcome, everyone. Today marks the beginning of a year-long lecture series at Harvard Law School. This is a momentous time and a deeply fraught one for the Supreme Court and for American constitutional democracy. The court's recent decisions, from abortion rights to gun regulation to voting rights to the functioning of the administrative state, have had a profound and profoundly controversial effect on the lives of Americans and on the US constitutional order. So this lecture series will bring together leading scholars, advocates, jurists, and journalists to investigate the role of the Supreme Court in a constitutional democracy. And today's panel is about the relationship between law and politics in the Roberts Court. Our focus is really the question of how should we understand the Roberts Court? Is it primarily a political or a legal institution? To what extent does the interplay of law and politics on the court mark a break from prior practice? Or to what extent does it bring into view more structural and enduring aspects of the relationship between law and politics on the Supreme Court? And where should we go from here? What does this interplay of law and politics mean for the role of the Supreme Court, the role that a Supreme Court should play in American constitutional democracy? So it's a total privilege to be joined by the panelists that we have here with us today. They need no introduction, so I'm going to be extremely brief. Will Baude is a professor of law and the faculty director of the Constitutional Law Institute at the University of Chicago Law School, where he teaches and writes about federal courts, constitutional law, and conflicts of law. He's the co-editor of a casebook on the US Constitution, an affiliated scholar at the Center for the Study of Constitutional Originalism, and a member of the American Law Institute. Amanda Hollis-Brusky is professor of politics and chair of politics at Pomona College, where she teaches courses on American politics, constitutional law, and legal institutions in the politics department at Pomona. Her research examines the dynamics of constitutional change and the role of support institutions and structures like lawyer networks, as well as ideas. Adam Liptak is the Supreme Court correspondent of the New York Times, where he's been covering the Supreme Court for well over a decade. He's written a sidebar on developments in the law since 2007, and his series on the ways in which the US legal system differs from those of other developed nations was a finalist for the Pulitzer Prize. Leah Littman is a professor of law at the University of Michigan Law School, where she teaches and writes on constitutional law, federal courts, and federal sentencing. She's also one of the co-hosts and creators of the much lauded Strict Scrutiny podcast, a podcast about the Supreme Court. And Janae Nelson is the president and director counsel of the NAACP Legal Defense Fund, the nation's premier civil rights law organization, fighting for racial justice and equality. She's also a renowned scholar of voting rights and of election law. So welcome to our panelists. We're just deeply, deeply thrilled to have you here with us and to reflect on these important and hard questions about the role of the court in a constitutional democracy. I'm going to open up our conversation by posing a question to each of you, which is also very much an invitation to offer a few minutes of initial remarks or reflections on our topic more generally. And then we'll use the balance of our time to have as much of a conversation as we can among the panelists, reserving a few minutes at the end for questions as well from those in attendance. So I invite those of you viewing this panel to go ahead and submit questions through the Q&A function. So the relationship between law and politics in judicial review and on the Supreme Court in particular has been a longstanding fixation in the United States and also globally. But it's taken on renewed urgency and momentous consequence in our current times And that's no more starkly observed than in Dobbs versus Jackson Women's Health Organization, where the Roberts Court reversed a right that the court itself had recognized for nearly 50 years and transformed in one decision the legal and the political landscape for reproductive rights in America. And in response, the joint dissenters in Dobbs argued, quote, that today the proclivities of individuals rule. The court departs from its obligation to faithfully and impartially apply the law. And then, quoting from what was the final dissent that was penned by Justice Thurgood Marshall before he stepped down from the court in 1991, the Roberts Court dissenters urged, "Power, not reason, is the new currency of this court's decision-making." So, Leah, I wanted to start with you because your writing has really called into question the idea that what judges ever do is impartially apply the law. And that when we think about this fundamental question of, is the Supreme Court a political institution, we need to really understand what we mean by politics and the different ways that politics can inform what happens on the bench. So how should we understand the role of politics in Supreme Court decision-making? And in particular, does the Dobbs decision mark a breach or a break from prior judicial practice?
So in some ways, as you suggest, it's a complicated question because it depends on, what is politics, what is political, what is legal, and the role of the Supreme Court, in a constitutional democracy. But in another very real way, I don't think the question is that complicated at all. And one thing I want to impress on people who may be listening now or listening later is not to, hand over the question of whether the court is engaged in politics to a bunch of lawyers or law professors in the same way, like we have handed over to the Supreme Court the ability to decide so many questions, that are so important to our country. Like on some level, right, like you can answer for yourself whether, a political campaign that was premised on the idea of appointing justices to the Supreme Court to overrule Roe versus Wade, that then successfully resulted in the appointment of justices who overruled Roe versus Wade, is political or not, even though we can have some really interesting and complicated, questions about how in the past the court has been political in, more complicated ways or not. So on some level, how should we understand the role of politics in Supreme Court decision-making is just not to avert our eyes to what is happening and, not to overly complicate or ignore, what we observed over the last year. I do think that what is happening now is more pronounced and complicated by some developments in American politics, in particular, the polarization of the political parties, which made it easier and also more important, to appoint justices whose views aligned more closely with the views of a political party, rather than, appointing someone whose views were more idiosyncratic or, spanned, different positions between the two parties. But, on another level, I know, the question is about Dobbs, but I also think the question about, the role of politics in Supreme Court decision-making is also a question about the role of Supreme Court decision-making about politics. And I think a big part of this question is, what is the Supreme Court doing, to our politics and our political decision-making? And I'm sure we will get into this later on in the conversation, but, in a term where we are facing down the prospect of the Supreme Court essentially nullifying the protections of the Voting Rights Act against, diluting voting power of racial minorities and potentially greenlighting, state legislatures to, kind of limit voting rights and not allow state courts and state constitutions to protect them. I think that that is also very much, a part of what it means for, politics to have a role in Supreme Court decision-making and the Supreme Court to be related to politics.
Okay, great, thank you. So Amanda, let me turn to you and And also, just to recall, the Dobbs dissenters talk about today the proclivities of the individual's rule. But in some ways, your work suggests that there's something much more programmatic and much more structural at work here. And so in light of that work, can you tell us a little bit about how changes in American politics and institutions over time, and in particular, the rise of the Federalist Society that your work has so painstakingly documented, how did those help us to better understand the current moment?
Yeah, thank you, Daphna. And I mean, I teach a course called Law and Politics at Pomona College. It's an upper division course. And at the very top of the syllabus is a quote from Tocqueville. Scarcely any political question arises in the United States that is not resolved sooner or later into a judicial question. And so I want to emphasize that this intermingling between law and politics is nothing new in the United States. In fact, there are certain underlying features of our system that invite and even require it. Right? We have a fragmented system of government. We have a politically selected judiciary with the power of judicial review. And in the 20th century, I want to identify 3 trends that have really kind of kicked that relationship into hyperdrive. And so the first would be just a rise of a demand for what Lawrence Friedman calls total justice. This idea that if the technology exists to protect us and keep us safe, that the government should protect the people, right? We want to make sure when we step onto an elevator that it's not going to fall, that our airplanes are safe, that our food and water are safe. But when you increase the demand for total justice and you layer it on top of a set of fragmented institutions, right? Power is divided so many ways in the United States that those demands end up hemorrhaging into the court. And this is really well documented by socio-legal scholars, kind of the rise of litigation in response to these demands for total justice. The second trend I want to point out about the 20th century is that the Warren Court, in many ways, developed a new function. The court has long been a traffic cop, right? Thou may not, or thou may. And Gordon Silverstein points out that beginning with Brown versus Board of Education, the Supreme Court developed what he calls the command function. Thou must, telling states, telling police, telling other branches of government what they must do. And so the Supreme Court really signals with the Warren Court that it's willing to expand its power and that it's willing to engage in politics in ways that it had been tentative to prior to the mid-20th century. And then the final development, and the one that kind of brings us closer to the contemporary period, is what Leah mentioned, which is the rise of polarization between our 2 political parties. And so political scientists refer to this as the ideological distance between Republicans and Democrats. And for those of you who are listening who may have grown up in the 90s or 2000s, our parties were not always so ideologically distant. In fact, prior to the 1980s, there's no meaningful difference really between Democrats and Republicans. They occupy every ideological niche. And there's a lot of what political scientists called cross-cutting cleavages that allow the parties to collaborate, right? And since the 1980s, the parties have been pulling apart. And because we have a politically selected judiciary, the sort of rise in polarization has now been reflected in our courts, particularly when we look at the Roberts Court. Since 2010, and I think this is the moment to identify, the Supreme Court has not just been divided along ideological lines, that sort of always existed, but divided along partisan lines, right? With every justice appointed by a Democrat voting more liberally than every justice appointed by a Republican. That is far from the historical norm, right? And I want to emphasize that. It's also the Roberts Court has been the most sharply divided of any Supreme Court since the New Deal, right? Issuing divided and divisive rulings, often 5-4 along party lines, on issues such as not only voting rights, but who gets married, housing discrimination, reproductive rights, healthcare, separation of church and state. And so the current partisan divide on the Supreme Court is amplified by the fact that all six of the Republican justices have identifiable ties to a single group, right? The Federal Society for Law and Public Policy Studies. I write extensively about the Federal Society and ideas with consequences, but for the purposes of this panel, I want to emphasize just one point about the organization. Over the past 3.5 decades, the Federal Society has achieved, and I'll quote from one of its members, a de facto monopoly on the training, selection, and disciplining of Republican appointed judges. And over the course of the Trump administration, echoing Leah's remarks, this influence has become at once more visible and more consolidated than ever before. Let's think about Trump's list, right? Federal Society approved, co-branded itself with the Trump administration, and made Scalia's seat, and thereby made the Supreme Court an election issue, right? Kind of further straining this tension between law and politics. And we know it worked. Exit polls tell us that voters turned out and voted for Trump, who otherwise would not have voted for him because of that list, because of the combined efforts of the Federal Society and the Trump administration. And so all of this has consequences for court legitimacy. As we know, the only currency that the court has is its power to persuade, its legitimacy. And we know from political science that the greatest threat to the court's legitimacy is when people believe that they're just another political institution, right? Politicians in robes. Now, whether or not these justices are actually motivated by partisan allegiances, that really doesn't matter. It's whether the people believe they are. Whether or not the 6 Republican appointed justices are motivated by their allegiance to the Federal Society, that doesn't matter. What matters is that the people believe they are, right? So what it looks like and how it's perceived by the public matters. And that's why I believe that we're hearing talk about court reform, court packing, and court curbing for the first time since 1937, right? People no longer view the court as legitimate. And it's not just about the intermingling between law and politics. That's always been there. It's the sense that law is nothing more than partisan politics. And I think that's the dangerous place we find ourselves in right now.
Great, thank you. So Will, let me turn to you and ask you a bit more about how should we think about this phenomenon of a Federalist Society supermajority, or 6 justices with ties to the Federalist Society organization. Should it inform how we think about the interplay of law and politics on the Supreme Court?
Thanks, Daphna. Yeah, thanks for asking that. And I guess I have a slightly different perspective on the whole thing. So I feel like I have to step back for just a minute and explain how I see this and how the Federal Society fits in. So I do think there's been a change on the Roberts Court about the relationship between law and politics. I think there's been quite a break from prior practice, and the Supreme Court sort of is performing a different role than it used to. But I think the difference is that the court is now much more committed to law at the expense of politics than any time in our memory, and indeed for decades before that. And I know that this is going to sound like a crazy claim, but I do think it's true and actually explains a lot of the controversies about the court. I think the majority of the court has a strong view about what the law is and how it works. Some people label it originalism. I don't think the label's that important. But in terms of the need to pedigree legal actions to the Constitution, to other texts enacted under the authority of the Constitution, like statutes, and to find that kind of lodestar more important than a lot of subsequent developments, subsequent popular views, subsequent precedents. I think there's a sort of a real anchor to the court's jurisprudence and legal views, and that's new. Now, 3 points about that maybe explain how I could possibly think that, and that get at the Federalist Society. So one, the fact that the court is committed to law over politics actually makes it seem more radical than previous courts, not less, because it means that the court is less inclined to just kind of tack toward the center in high-profile cases, or to, use public opinion as a anchor or a bellwether, because there's something else, law, that they feel even more drawn to and more committed to. It makes them more willing to overturn a lot of precedents and sometimes to disregard procedural rules, because again, those things are kind of common law, like judge-made practice, that have a lower status than the fundamental law the court feels obliged to uphold. So that can cause them to do more dramatic things rather than less, because law is pulling them there, not just prudence. I think, we could talk about whether that's a good or a bad thing in the broader sense, but I do think it means that sometimes the court can feel like a shock to those of us who've grown accustomed to centralism and gradualism. Second, and this gets to the Federal Society point most directly, the fact that the court has a theory of law doesn't mean that it's a coincidence that a lot of the justices' theory of law is producing a lot of conservative outcomes. right? The justices were chosen by a political process that is indeed sort of more polarized, more focused, more partisan than it has been in the past. I think they do come by their legal views honestly and legally and don't think they're doing partisan politics when they do it. But other people who are also have honest legal views that just, were different and had equally excellent credentials didn't get the commissions because politics sort of operates to pick a certain set of people. And even if they honestly think they're doing law once they're justices, the fact they're justices is not a coincidence. And that's where, the role of politics in picking the justices, the role of groups, maybe the Federalist Society among them, in sort of elevating some people to prominence or causing some people to get to know other people is really important. So that's still all going on. But I do think it's really important to see where it's happening, that it's happening in politics and not at the court. Again, maybe that doesn't matter. Maybe what matters is perception and not reality. But I guess I'm naive enough to think that figuring out the reality does matter, and that it's important to at least talk about that and thinking about the court going forward. And then, of course, the third point is that I don't want to say the court is getting the law right all the time. Like all law professors, I spend a lot of time telling the court what it should do in lots of cases. Like a lot of law professors, I'm ignored most of the time. And I think when the court, doesn't do what I think it should, I think it's wrong. But I think they're trying to get the law right, even if they aren't always accepting the legal arguments that I think they should be accepting. Now, what should we do about that? Maybe the answer is this just proves the need for court reform, right? Maybe the fact that the justices honestly believe this stuff, maybe that's even more scary for people who don't agree with it. Maybe it means the only hope is court backing or what have you. But I do think for people who do want to work with the institutions we have, that it's important to realize the kinds of arguments and the things that are actually moving the court, which I think are internal legal arguments of the kinds that they themselves are describing their opinions, not the kind of political arguments that a lot of people may think are motivating it. And that for advocates and other people working within the system, it's important to see that whether we like it or not, this is a court with a theory of law, and they're gonna follow that theory of law, even if it takes them far away from where the rest of us want to be. Thanks.
So Janae, I wanted to ask you, from its founding, really, the NAACP has been both a participant and also deeply shaping what have been longstanding debates about the use of the court and of litigation as a means of social change. And so how do and how should concerns about a more political court, a more partisan court, a more ideologically conservative court, how should those affect advocacy and litigation strategies today in the pursuit of equal justice and the pursuit of building a more multiracial democracy, as Leah mentioned, bringing in as well the questions of what the court is doing to politics itself?
Sure. Thank you so much for that question. And this is a great opportunity for me to clarify the Legal Defense Fund and our distinction from the NAACP. We started as part of the NAACP in 1940, but became a wholly separate organization as of 1957. And I appreciate you opening this with a quote from Thurgood Marshall, who was our founder. And he was quite prescient, I think, in seeing what the court would ultimately become. And also to remind us that this court has been politicized for some time. And it's important that we recognize how over time that has calcified in ways that are now forcing this court to overturn precedent that we've come to rely on. This is really a significant break from the court's trajectory over time, which has largely been one of expanding rights, explaining them, narrowing the conception, or giving us different tests through which to determine their legality, but overturning them and reversing rights that we've all come to rely on is actually something quite new. And so I'll just say that the Legal Defense Fund has created so many victories through the use of the Supreme Court. And you talked about our work advancing equal justice. That has certainly slowed before the Supreme Court over time, given its more conservative slant. And in terms of just the practical result, we have to think much more carefully about the cases that go before the Supreme Court. There was a time when the Supreme Court was an avenger of the Constitution and the right to equality, the 14th Amendment, and ensuring that the Reconstruction amendments had some form of life. They were never fully realized, even by the Warren Court, but there was an opportunity to create a doctrine around the 14th Amendment, in particular, the Equal Protection Clause, that really expanded our conception of equality. And we're seeing, unfortunately, a significant rollback of that. We have worked for over 80 years to fight for the rights and full recognition of the dignity and humanity of every person in this country, and especially Black people who have been subjugated under the law in many ways. And when Justice Marshall said that power, not reason, is the new currency in this court's decision-making, he followed it up to say something else that I think is worth sharing. He said the majority's debilitated conception of stare decisis would destroy the court's very capacity to resolve authoritatively the abiding conflicts between those with power and those without. If this court shows so little respect for its own precedents, it can hardly expect them to be treated more respectfully by the state actors whom these decisions are supposed to bind. Fast forward to early last year, when 5 justices on the court diverged from Chief Justice Roberts and allowed Texas to flagrantly dismiss this court's precedent and allow state action to override what has historically been the protection of abortion rights. It is no surprise then that the Dobbs decision would turn out the way that it did. The writing was on the wall, the flouting of the court's precedent was already occurring. And I would say we should question whether we can actually call this the Roberts Court in anything other than a very technical sense, in that he's the Chief Justice, because he no longer can control what is now an extremist conservative majority, supermajority on the court. So this question of whether the court has become politicized, I think is really fraught. Because on the one hand, we want to ensure that the rule of law is respected, that our institutions, our third branch of government, continues to be decisive on what the law of the nation is. However, when it acts in such a politicized way, it makes it very difficult for people like me and people who do the work that we do at the Legal Defense Fund to continue to point to the court as an institution whose decisions ought to be followed, whether or not we disagree with them, but because it is an institution and an actor that has a presumption of objectivity and a presumption of being apolitical. That is increasingly difficult, and people with different ideological backgrounds are more likely to reach different conclusions about where we are with the court. But I think it's very difficult to say that this court is not facing a crisis in confidence, that at least according to recent opinion polls, the court's popularity is in free fall. And this is something that is quite different, I think, than earlier iterations of the court. The arrival of Justice Amy Coney Barrett solidified that 6-3 conservative supermajority that has been quite rogue, I think, in many of its decisions. And that difference is most garishly displayed in the recent Dobbs decision, which, as I said, while it was a blow to many, the writing was on the wall, and it was quite predictable that the court would engage in this disrespect of its own precedent.
Thank you very much. And Adam, so let me ask you, we've heard a few times the idea of the perceptions of the court, and as Janae just said, the crisis in confidence that we're seeing of the court right now. So how do current perceptions of the Supreme Court affect the discussion that we as a country are having, the conversation that we as a society can have about what is the appropriate role of a Supreme Court in American constitutional democracy?
Well, so maybe let me bring it full circle to where Leah started. Public perceptions of the court matter, and they have been, the approval rating, the confidence rating has been dropping. as it does whenever the public perceives the court to be a political, not a legal institution. And that perception is fueled by radical departures like Dobbs. It's fueled by the important point Amanda made, that the court these days is perfectly predictable in a partisan sense. That is, the Republican appointees all vote to the right of the Democratic appointees. As she pointed out, that's a new phenomenon. It wasn't long ago that you had Warren, Brennan, Blackmun, Souter, Stevens, Republican appointees who were essentially liberal. O'Connor, Kennedy, who were moderate conservatives. Byron White, a conservative Democrat. So you didn't have this kind of overlay. And when the public perceives that there's a political element to judging, it's offended because it thinks the law is a different realm. It's prepared to accept this anti-democratic institution because it's doing something other than politics. And when it sees something different, it's upset. Now, I think I can accept Will's point that the justices are acting in good faith. Michael Klarman, the Harvard law professor, over the weekend had a quote in the paper saying that the Republican appointees won't say it and may not believe it, but they are executing a Republican agenda. And that's a consequence of the constitutional structure. Supreme Court appointments are political by design. The president, a politician, appoints. The Senate, made up of sophisticated politicians, confirms. And so there's politics on the front end. And oddly, the major constitutional way we want to give the justices independence, which is life tenure, actually injects politics on the back end, because they make strategic decisions about when to retire so that they can be replaced by someone ideologically similar, or they make a bad bet and die, and happenstance allows a president to appoint someone. So you really have a situation where it's imbued by politics, and you can have these justices operating in perfect good faith, but nonetheless are guided missiles whom will, for legal reasons, execute a political agenda.
Great. So we've put a lot on the table, and let me take a few minutes to just invite the panelists if they'd like to ask further, to respond to anything that's been said so far before we dive into questions.
Daphna, I'll say this. I talked about the fact that it was not unsurprising that the Dobbs decision would come out the way that it did, but I also want to ensure that we recall that this isn't a recent phenomenon. If we think back to nearly a decade ago, when the court rejected about 50 years of precedent surrounding the Voting Rights Act and disabled Section 5 and led to what we are currently seeing as a tidal wave of voter suppression, that was a signal. And then the court was composed in a very different way. So while this supermajority of conservative extremists are, I think, a little less veiled in their actions, this court has already been, and at Roberts' direction and hand, I mean, he quite clearly has no love for the Voting Rights Act, was willing to overturn its precedent in other contexts. And so this is now a runaway train, and one that he can no longer control, but one that he helped to set in motion.
The only other thing I would just add is I feel like there is a spectrum between saying, our constitutional system injects politics into the courts in some way, and judicial appointments are political, right? And the world we are living in, which is, the parties are so polarized that they are able to select judges whose vision of law happens to lead them to perfectly implement, that party's political agenda. And that's not a world in which the public would, as Adam was saying, think, yes, like we should just allow these decisions to be made by, right, the unelected group that isn't accountable, if they are just going to be reaching the same decisions, that the elected version of or elected branch of the party would, when we at least would have the opportunity to register our content or discontent or do something about that, if those decisions are being made by a comparatively more democratic branch of government. And does it really matter, in my view? Like, the reality is, that is how the parties are selecting judges and justices. So you can describe that as, right, doing law or doing something else, but that is kind of the system we have arrived at.
Because I'll jump in to say, I think we could also get a false picture by thinking that it's the overlap between the court's high profile cases and Republican Party politics is 100%. It was just a couple of years ago when lots and lots of Republicans were making sort of irresponsible arguments to the court, trying to get them to step into the 2020 election, which the court refused to do. We're trying to get the court to invalidate the entire Affordable Care Act, which most of the court refused to do, or threatening that the Republican Party needed to get rid of the Federalist Society and originalism because it had produced Neil Gorsuch, who had produced Bostock, which was an unforgivable crime. So these things it's not like the court literally sits there enacting only the things the Republican Party wants. Now, obviously, the correlation is a lot more than people who are not conservative are comfortable with, and I understand where the perceptions come from. But I do sometimes worry that by only focusing on the 5-4 cases, we miss all the cases that aren't 5-4 and all of the ways in which the court is still kind of doing the normal stuff too.
These days, you're lucky to get a 5-4 case.
I just wanted to jump in and recommend an article based on what Janae was talking about. Pam Carlin's article, Democracy and Disdain, thinking about how the Roberts Court's decisions, not just on the Voting Rights Act, but campaign finance, busting unions, how viewed skeptically, all seem to tip the electoral scales in favor of the Republican Party. And again, this is another perception issue that I think is really important when we think about the court's legitimacy, what they appear to be doing, and the real life consequences of those decisions.
Great. So let me also ask, Will, I'd love to push a little bit on the claim that this is a court that is more committed to law, even at the expense of politics and originalism as kind of the argument for that. Because in the legal academy, we've often analyzed originalism from the perspective of a kind of values neutral constitutional theory, and we've assessed it in those legal terms. And Riva Siegel, at Yale has published an article recently that has made the argument that actually we in the legal academy, we in the public talking about what the court is doing, really need to understand originalism as a political project, as a political project that's been a multi-decade political practice of the conservative legal movement that today, in her words, is embedded in the Republican Party. So I want to invite Will first, but then I also welcome other panelists who have thoughts. How should we analyze the work of originalism on the court, and to what extent is it also a set of legal ideas, but also a set of political ideas about constitutional power and about democratic society and what it can look like today?
Well, I'll go first and put the target on my back. I think originalism is a tool for thinking about law. I guess some would say a weapon for thinking about law that's been wielded and can be wielded by different groups depending on where you stand in relationship to law and politics. So I'm teaching here at the University of Chicago, where the most famous and prominent originalist law professor of the middle of the 20th century was. And I'm speaking of William Winslow Crosky, not Antonin Scalia, who wrote a 3-volume book on the Constitution of the United States, arguing what were at the time completely radical ideas. The original meaning of the Constitution supported vast congressional power, that supported the incorporation of the Bill of Rights, a range of other things that had him almost laughed out of the academy at the time. And of course, many of them came on to become conventional doctrine. At the same time, the most prominent originalist in the court was Hugo Black, who was in many ways one of the most liberal members of the court. And then obviously the polarity of that changes a lot a few decades later. And I think that's unsurprising because one of the resources originalism offers practically is the ability to radically critique doctrine where it stands, right? To throw over lots and lots of precedent and stare decisis, but with a rationale that at least sounds in the rule of law to respond to the kind of allegations like the ones we've talked about. And so it's unsurprising that in the 30s and 40s, the New Deal liberals were the ones who needed those resources, who needed to explain why the Gilded Age shackles of the court had imposed needed to be overturned, why they could get rid of constitutional rights that everybody had enjoyed, like the Lochner rights. And then unsurprising that a few decades later, once the shoe was on the other foot, the conservative legal movement finds itself sort of using the same weapon and the same arguments to do the same kind of thing in the other direction. And again, I realize it sounds naive to say this, but I think originalism is a legal theory. It's a tool for thinking about the law. I think a really helpful one, but it's definitely one that can be swung by our enemies and our friends.
I guess I would just jump in and say it wasn't too long ago. In fact, you can look back at the kind of earliest meetings of the Federalist Society where they were embracing what they called judicial restraint. The idea that judges should not overturn legislation, democratically enacted legislation, unless they absolutely had to, right? Unless the Constitution absolutely commanded it, that they shouldn't unsettle precedent too quickly, right? This is the J. Harvey Wilkinson School of Judicial Restraint. And what I've seen and what I've observed over the last 30 years is that the Federalist Society has moved from embracing that idea of judicial restraint, like a minimalist role for the judges in American democracy, to this rebranded idea of judicial engagement, right? This is the Clarence Thomas, you go as far as the law takes you, even if you burn Rome to do it, right? We should wind back the clock all the way back to 1937 when the court first took a wrong turn, dismantled the administrative state, to hell with the consequences. And to me, that is different. And I think that has to do with one thing, which is political power. And so it's an interesting shift in my perspective, originalism as justifying judicial restraint and originalism as now licensing this kind of new form of what I would call judicial activism and what they would call judicial engagement.
I mean, I can just add that if you haven't read Reba Siegel's article, Memory Games, definitely check that out, as well as Jamal Green's on the origins of originalism. I think they make persuasive cases in the piece that, originalism as practiced in the courts and in the other branches of government, is a way of making value-laden arguments about the future, about who we are and who we should be as a people. And that, again, as is being practiced right now, originalism is a way to challenging those rights that opened up, democracy, civil society to a broader group of people, including those, who were historically excluded. And that, again, as practice, it is a way of appealing to and reinstating norms, traditions, and ways of life that are associated with status-based hierarchies. And what it does is it seizes the claim of it is for us courts to decide the meaning of history, the values that we made as a people, and you don't get to decide that. And you have to defer to our court's vision about what the history is and who we are as a people. And I think both Professor Siegel and Professor Green, make that case in different pieces that survey different examples of originalism in the courts and outside of it.
I'd also add that originalism, even if you accept it, is very hard to do. The Supreme Court has not distinguished itself with its historical research. Actual historians think that its work is quite poor. And then think about what the district court judges meant to do. The recent guns case says, well, you should do some historical research and reason by analogy about whether the AR-17 is like or unlike a musket in relevant respects. It's indeterminate, it's hard to do, and therefore it seems somewhat troublesome.
Yeah, can I just add, I think it's important to highlight some of the recent comments of the Chief Justice, who I think is trying to mount a campaign of trying to rehabilitate the court's image here. And he kind of chided those of us who would warn that the court's conservative supermajority is using its power recklessly. And, you know, he said, you don't want the political branches telling you what the law is, and you don't want public opinion to be the guide about what the appropriate decision is. And I think that's generally true, but it's hard for him to make those statements in the face of the decisions that we've seen. After all, it is not the political branches or public opinion that have brought so much scrutiny to the court's recent decisions. It's the ambition or even the radicalism of the decisions themselves that have incurred this backlash. So this is the same Chief Justice who infamously referred to the sordid business of divvying us up by race, who presided over the decisions that vitiated the Voting Rights Act. And we see the havoc that has been wrought as a result of that decision. And it's gone on to really cement and in many ways lock up this partisan minoritarian rule that I think is leading to the results that we see. And Adam pointed to the politicization of when justices retire or how the court gets composed the way it is. And none of that is, or rarely is it just by happenstance.
So let me ask both in the opening remarks and in the comments so far, there's a few different ideas that we've been talking about. And one is the court is a political institution and the way in which political ideology influences what the court is doing. The other is the court as an increasingly partisan institution. And Amanda talks about the increasing partisan divide on the court in the current era. And then the third that I think we've started to talk about now is the court as an inadequately representative institution, which is a bit different, but also quite important to this thinking about the relationship between law and politics. So Steve Levitsky in the New York Times yesterday said that we are far and away the most counter-majoritarian democracy in the world. And one concern is that the way in which the court entrenches that counter-majoritarian power is today interacting with other aspects of minority rule or entrenching a minority rule in the country. So there are these different ways in which the question around politics and the court is playing out. And I wonder if we can gain some clarity about, is it the kind of the confluence of these different ideas that's creating the sort of crisis of confidence that we're talking about? How should we think about these different kinds of political considerations?
I can start unless someone else wants to. What I would just say is, again, like, line up all of the court's decisions over the last 10, 15 years, related to politics and the law of democracy, and kind of ask yourself, like, what's going on here, right? You have Brucha versus Common Cause, which said partisan gerrymandering isn't justiciable, allowing legislatures to draw districts in a way that insulated themselves from voters and democracy, right, to stay in power despite the will of the people. You have Shelby County versus Holder, which Janae alluded to, that allowed, states to, free of the restrictions of the Pre-Clearance Act, enact measures that disproportionately burden voters of color. You have this upcoming court's, terms decisions in Merrill versus Milligan, in which the court is going to make it easier for legislatures to draw districts in ways that dilute the voting power of racial minorities. You have Harper versus Moore, in which the court is going to say, state courts can't protect voting rights and guard against partisan gerrymandering and other anti-democratic measures on the basis of state constitutions. You had, Brnovich versus DNC, in which the court watered down the protections of the Voting Rights Act when it came to preconditions on voting. You have 3 seats in the House of Representatives in which the Supreme Court said, jettisoned them for majority minority districts, essentially allowing Republicans to get 3 seats that they wouldn't have had, but for these lower court decisions. And it's like, okay, well, I guess, the plain text of all of the statutes and all of the Constitution just happens to favor, like, the Republican Party in case after case, right? Like, that's one vision of, like, what law is. But, like, it is, I think, a disservice to our democracy and our constitutional system to just keep allowing the courts to treat, our institutions and our democracy as a punching bag, and to make them, less democratic and less representative in a way that does, like, undermine faith, not just in the Supreme Court, but in other institutions as well, that are increasingly divorced from the views of the public, the will of the voters, whatever you want to say. And it is, very scary to look at in the aggregate. Again, you can kind of abstract away from it, right? And come up with theories that like attempt to make it sound like less scary, but I just don't think that is a sensible way of structuring, right, a constitutional democracy.
It wasn't long ago, well, I mean, it wasn't too long ago, that the Supreme Court viewed itself, one of its primary functions is democracy reinforcing. And that the default ought to be to make democracy work better. Earl Warren said the greatest cases of his time, and this is the court that decided Brown, the greatest cases of his time were the one person, one vote cases. And there was a time when John Hardy Lee and later Steve Breyer made that, the central claim in what the Supreme Court ought to be doing, which is enforcing democracy. And you could easily make the case these days that it's doing quite the opposite.
I do think there's a sort of a less scary, less nefarious way to see those things happening, which is that sort of democracy reinforcing project was in tension with some of the things in the Constitution itself, because we have a very old and not particularly democratic Constitution that doesn't contain basic things that it should contain, like a sort of a right to vote or a rule against partisan gerrymandering, at least in plain terms. I mean, the fights in the cases is about whether it does contain one or not, but it doesn't contain it in the plain terms we'd like it to see. So you can also see a lot of the court's law of democracy cases as just repeating a lot of the same phenomena of, intense skepticism of unenumerated rights, hyper focus on the constitutional text, sometimes too much focus, I think, as in the independent state legislature cases, which I think are misguided, but it's kind of what you'd expect from the court. Skepticism of federal law and attempts to restrict the enumerated powers, skepticism of precedent that doesn't adhere to the court's own methodological points of view. So I think you can see it as just another artifact of the court's theory of law, which was controversial for the reasons we've talked about. I'm not so sure that the cases have the partisan effect that they often reported to. I think the people who are doing the most intense empirical work on the independent state legislature doctrine suggest it may be a wash, depending on what happens to partisan gerrymandering in New York and California and other blue states. That a lot of the ballot access cases that matter a lot to individuals and to lawyers may just not, move the vote totals very much. So I do sometimes worry we're sort of ourselves feeding a cynical narrative about the Supreme Court that may be overstated. And the more we tell people that the court is going to destroy democracy and keep it away from them, I guess it's the more people are going to believe it. But I do worry that we're actually doing the world a disservice by sort of fear-mongering about that.
So let me ask you guys, because this is a question that's come up in a few different guises, and in the questions that are those participating on the webinar have started to send in. Where do we go from here? So if the court has become political in ways that some people are extremely worried about, whether you take it in terms of its ideology, its partisanship, or its unrepresentativeness, to the extent that for some part of the country is a deep concern today. Is the answer less constitutional law? Do we want less of the court say on these issues? Is it about changing the court? Where do we go from here?
I think we should just accept that the court's doing law and be okay with it.
I think the court should be a lot less important than it is. So as an originalist, I actually think that the sort of modern drive towards judicial supremacy that currently is very convenient for conservatives and was previously convenient for others is a real disservice to the Constitution's history and tradition. And that the tradition is that the Constitution is, held equally by all of the elected branches, and ultimately by the people themselves, who shouldn't forget, as Leah pointed out at the beginning, that that they have a lot of agency in amending the Constitution or participating in politics to promote a very different vision of constitutional law. And I think we really need more of that. And I think to some extent, conversations like this are kind of a symptom of the disease of judicial supremacy, that we've all come to accept that the Supreme Court just rules us all and at least do nothing but squabble over who controls it and try to pack more of our people onto it rather than more of the other people's. And if instead we could sort of all try to move past the court as much as possible, to give it less power, to diminish it to sort of the proper kind of jurisdiction, and to put more of our effort into real constitutional politics, I think we'd have a much better chance of survival.
Will, is that a thought experiment, or would you go so far as to consider jurisdiction stripping measures?
No, it's not a thought experiment. I think jurisdiction stripping is always hard to. I think it's hard to craft in an effective way, sort of across the board. But it's quite easy to craft in an effective way for particular cases, and I think people should be less afraid to do that when they think the court is. I think jurisdiction stripping is still sort of not enough compared to real departmentalism and asking our elected representatives to take the Constitution more seriously.
I just think it's very difficult for us to think about the role of the court and its power without a reckoning with the ways in which our entire system is so very counter-majoritarian, and a good look at Congress and the Senate in particular, and filibuster rules, and so many ways in which the Congress does not represent the will of the majority, and the court is in theory a backstop to some of that. Unfortunately, it seems that the court has been captured, and I don't think that it's hyperbole to say that, or that it's it's fear-mongering without justification. If we look at the decisions of the court, it has reinforced a way in which there's almost no way for majority will to carry the day. If I think about the cases that we've been litigating, like the Alabama redistricting case, a Louisiana redistricting case, where lower courts have said that those congressional maps are in all likelihood racially discriminatory, and yet the court has fashioned a principle out of Purcell versus Gonzalez, which isn't even a rule, to allow discriminatory maps to govern congressional elections in this upcoming midterms. And regardless of what the outcome is ultimately in those cases, the election results that come from those districts and those lines that are racially discriminatory will govern. There's no reversing that. And that's something that the court put in place in a way that I think was absolutely unjustified. So the court is not sort of rebalancing, even after it said that there are other mechanisms to deal with partisanship and gerrymandering, et cetera. The court is not following its own words in being a neutral arbiter of these types of political skirmishes. And if we're talking about thinking of how we recast the court and its power, we can't do that in a vacuum. It has to be part of a real evaluation of our tripartite government.
And I guess I would go back to Adam's observation about the hyper politicization of Supreme Court appointments and how irregular and how up to chance they are. I think the only way to get out of this is to regularize Supreme Court appointments. And the only way to do that in a timely manner is to add 4 term limited seats to the Supreme Court, and then subsequently term limit every seat that comes up till we get back to 9. This proposal is bipartisan. It actually has support from both parties, and it acknowledges the realities of where we are today. We're not in 1789, where the average life expectancy was 38 years. And the average Supreme Court justices served 8 years, like a 2-term president. We are looking at a court that will be majority or supermajority conservative for the next 3 decades. And I think that is going to produce a lot more problems than our system can handle. So that would be my way forward.
And do you think that requires a constitutional amendment?
I don't. So I'm persuaded by the arguments about appellate court justices riding SCOTUS for a fixed term of 18 years. And then if they so choose, going back to the courts of appeals. I think that gets around the lifetime appointment issue. But of course, constitutional scholars are divided on this. And of course, this proposal would be subject to judicial review by the same 6 conservative justices who would be predisposed to not like this plan.
unless you strip the court of jurisdiction over it. So we've come full circle, and I just want to thank the panelists for a really phenomenal conversation. And Will said, you know, is this conversation part of the symptom of the malady? And I'll just leave you on a hopeful note that maybe it's part of the beginning of a cure. That if we are trying to recognize the politics that exist, if we're trying to think about what is a more appropriate role for the court to play, that it's conversations like this that need to happen, as Janae says, in the context of a broader conversation about our tripartite system of government, to work towards those steps of reform. And in future panels, as part of this lecture series, we will be talking both about stare decisis on the court and also about whether the court should be reformed. So thank you all so much for participating in this really thought-provoking, really illuminating conversation.